3, 2, 1. We had heard the above set of appeals and passed an order on 3/2/2021. Application for early hearing of the writ petition is allowed. List this case again on 23/2/2021. Rules were framed by the state government in exercise of powers conferred under section 12 of the Act. Rule 10 prescribes the process of admission to be on the basis of allotment of students who participated in the first round of counseling. The procedure for admission in second round 80 of counseling is dealt with Rule 2 and is found in Rule 12. The allotment of admission is governed by Rule 13. Amendments to the rules were notified 6/2019. However, his son did not get any employment, and when they went to the house of the appellant to ask for the return of the money, the appellant assaulted the complainant and threatened to get them false implicated in criminal cases, and the appellant purged him and his son from her house. The same was registered as case number 153/2013. Thereafter, the investigating officer filed the charge sheet against the appellant herein and one another for the offence under sections 419, 420, 323, 504 and 506 IPC. The appellant approached the High Court by way of criminal miscellaneous application number 5213 of the 2018 under section 482 CRPC to quash charge sheet dated 10/5/2017, as well as the entire criminal process, the impugned judgment and order. The High Court has dismissed 240 the application and has refused to quash the criminal proceedings and charge sheet. Hence, the applicant has preferred the present appeal. The appellants were included in the select list for 2011 and they were promoted to IAS in the vacancies. Respondent number 4 submitted his objections to the tentative seniority list, wherein the request for the period of service rendered by him in short service commission of the Indian Army and as Deputy Superintendent of Police to be counted for the purpose of calculating the total qualifying service. A final seniority list was issued on 17/3/2017. For the aforementioned reasons, the judgment of the High Court is set aside and the appeal is allowed. District Consumer Forum has no power to extend the time to file the response to the complaint beyond the period of 15 days in addition to 30 days as is envisaged under section 13 of the Act. Therefore, in the case on behalf of the petitioners, that the aforesaid decision shall not be applicable. Therefore, the National Commission has considered the aspect of condonation of delay on merit also. Stop.